Okay, everybody, we are going to get started. Thanks. And Ben will do the introductions again.
Okay, welcome back. We got another hour of entertainment and good information. This panel is a little different. We've heard from consumers. First, we heard then from the medical perspective from therapists and doctors. Now, we're going to broaden the view a little bit and sort of look from sort of legal and international perspective. And so we're lucky to have the first speaker is Judith Klein. And she is, first of all, she lives in Budapest, so it's already interesting, right? She has been the director of the Mental Health Initiative at the Open Society Foundation, that's George Soros's group, for the past 22 years. Okay. The Mental Health Initiative and it aims to ensure that people with mental disabilities are able to live as equal citizens in the community and to actively participate in society with full respect for their human rights. Okay. Well, we can all agree with that. She's working in Eastern Europe, where to put it mildly, they're behind us a little bit, if you can believe it. The initiative focuses on ending the unjustified and inappropriate institutionalization of people with mental disabilities by advocating for good alternatives. Okay, we've talked a little bit about deinstitutionalization here, about Reagan doing that. Well, the institutions there are a little more brutal, and there really are not many alternatives. I think she'd say that. Prior to being at the foundation, Ms. Klein, who is a member of the state bars of Florida and Michigan, represented people with mental disabilities in guardianship and involuntary detention hearings in the U.S. So, Judith, go ahead.
Thank you very much.
Yeah.
Do I have to push something or just on? Okay, so thank you so much. I'm incredibly honored that Ellen invited me to join this distinguished panel of speakers. I do bring a different perspective, which is the international one, because I have been working internationally for over 20 years. And in working in the fields of psychosocial and intellectual disability for all that time, the issue of legal capacity, or rather the lack thereof, has come up thousands of times. And it often comes back to one really big problem, which is institutionalization. The decades-long institutionalization of people globally, actually, for no reason at all, except that there's no decent support available in the community. And I have been outraged about institutionalization for over 2 decades now. It's become part of my life, really. But I think there's still too little outrage that millions of people are unjustifiably waiting, effectively being warehoused in long-stay institutions where often their property, unknown to them, is stolen by their guardian, whether that's a family member or someone appointed by a court. And then the other thing is that the issue of stealing from people when they're in institutions doesn't necessarily end when they get out of them. And a classic example of this kind of abuse is a small story I'll tell you about what happened to a guy named Neno. Neno is a Croatian guy who inherited the home he was born in and grew up in on the beautiful island of Pag on the Croatian coast. And he lived in the house with his mother the whole time. Then his mother unfortunately passed away, and he has intellectual disabilities, and he was put by default under guardianship immediately and into a long-stay psychiatric institution. A year later, Neno was lucky because we got him out into a very good community housing program, a supported housing program. But that's in Zagreb, which is very far from Pag, which is where he's from and the place he loves. His social worker became his guardian. And since he has no legal capacity, Neno actually doesn't have any rights. So he has a dream. He owns this house. This is it's his legal right. And what he wants to do is live upstairs with some friends and dedicate the downstairs part to a small grocery shop. It's a modest dream, I think. But because he has no legal capacity, he can't do any of that. He gets taken to POG every single month for a visit because he wants to see the house and he wants to be where he was born. But all he can do is stand in the front of the house and wish he had the key. The other problem with institutionalization as it relates to legal capacity is that during the time people are in institutions, they get absolutely zero experience in life and in making decisions. Everything is done for them. People in institutions aren't allowed to do anything for themselves. They can't make a cup of coffee. They can't decide to have a tea instead of a coffee. They can't decide when they go to bed or what clothes to wear. People know, after being institutionalized for decades, people know one thing, which is how to survive in the context of a prison-like facility where they can't get out. And so for someone to have legal capacity while they're stuck in an institution is really an empty right because it can't be exercised. And of course, it won't be a surprise to anyone in this room that there's been a ton of research on supported decision-making that has clearly shown that social exclusion makes it really, really hard to implement supported decision-making. So you all know about the Convention on the Rights of Persons with Disabilities. Of course, this country has not signed because it argues that it has better laws than the CRPD, which I would strongly disagree with in most cases. But Article 19 of the CRPD is kind of central to the work that I've been doing because that's about the right to live and be included in the community. And if that's not implemented because people are stuck in institutions, again, legal capacity and SDM only exist on paper. It's when people get out of institutions and get into good community-based services that are person-centered, where they begin to understand what self-determination is, when they start to talk to other people who have left institutions, they begin to experience a whole new world, and they get something that we all take for granted, which is a life, a regular life, where they decide what to do, where to work, with whom to live or not, by the way. And to illustrate how much discrimination there still continues to be, consider this story. This is in another Eastern European country. There was a couple who was in love and they wanted to get married, as many people do. But because they didn't have their legal capacity, they had to go to court and a judge had to make a ruling as to whether they were going to be allowed to get married. And it became a bit of a nightmare because it was an extended legal battle in the end, because this judge basically said that these people, because of their disability labels, do not understand the nature of love. And I thought, wow, that is a hot one. One human being telling another one that they don't understand the nature of love. That would never happen to a person who doesn't have a disability label. So the complete loss of control that people face when they don't have their legal capacity ranges from guardians stealing their property, as I've said, very commonly to having their children taken away for absolutely no reason except they're presumed to be incompetent, to a judge deciding that another human being doesn't know what love is. So the million-dollar question, where do they get it right on supported decision-making? Well, first of all, to be very clear, there is no country in the world that has fully implemented CRPD Article 12, which is the one that refers to legal capacity. So the broad brush answer is nowhere. We also know that there are additional challenges to implementing something like supported decision-making in low-income countries where the resources and the political will are going to be very difficult to, to get past, or the lack of political will, I should say. But there is one concept that does come through in SDM best practice consistently, I think, and it's the one that works best for people when the assessment of their capacity is based on how much the person can make decisions at that particular time, rather than assuming that the person is incompetent based on their diagnosis, or assuming that the person can't make a decision now because there have been times in the past when they were unable to make one. this approach obviously is positive because it's building on the person's strength and it's giving the person confidence. One model I do have that I can talk about as a kind of good news model is a best practice example from Finland called Open Dialogue. And it's a little bit of a variation, but it's very much person-centered. So the person with the psychosocial disability is at the center of the process. And then others, they invite others to be part of sort of a circle of support, if you want. And those are family members, loved ones, any professionals that they want to be involved. And then the people, all those people at the meeting are someone the person trusts, and everybody's participating in a very transparent way, but the decision is actually being made by the person in the end. It's a working model that's very effective. It's been shown, there's some research that shows it's very effective for people who are experiencing psychosis, because the minute a problem starts, the team comes together and tries to help the person get through it without having to be hospitalized. It has led to, the open dialogue model has led to enormous reductions in the number of unnecessary hospitalizations because there's the support that people need. I think there's an enormous amount of resistance to supported decision making, as all of you know, and I think that has to do with people, human beings in general, being risk averse. You know, when people are making their own decisions, risk is involved, right? Life is risk. We all make decisions every day that have risk. And we have to support people who have diagnoses to do the same thing. You know, this issue also, of course, comes up a lot with people who have intellectual disabilities, where they are put under guardianship in the name of their own protection. It's a very paternalistic kind of view, their own safety and protection. And just to end, I mean, like so many issues in mental health and intellectual disability, I think we often get caught up in talking about systems and processes and services and programs. And I think what we have to remember first is people, not pathologies. And I would call on each of us to use what I like to call the would you test. Which is whenever we're advocating on behalf of a person with disability, the first question we need to ask ourselves is, would you be okay with that? Would I be okay with this decision that I'm making? Because if it's not okay for me, it's not okay for someone who has a disability label either. Thank you.
Thank you. Okay, we're gonna move on with two others, and then we'll open for questions as we have been doing. Next up is Jim Preis, sitting next to me here. I'll tell you about Jim. He served as the executive director of Mental Health Advocacy Services for over 35 years.
Almost 40.
Okay. This group is a private nonprofit organization providing free legal services to people with mental disabilities. It assists both children and adults with an emphasis on obtaining government benefits and services, protecting rights, and fighting discrimination. Mr. Preis has litigated several significant cases on behalf of people with mental disabilities, lectured widely on the subject, and authored books, law review articles, and professional articles on mental health law. He teaches mental health law at USC Gould School of Law, and also teaches in the Forensic Psychiatry Fellowship Program at UCLA. So, Jim, go to it.
Thank you.
Yeah.
And today I'm going to be looking specifically at decision-making in the attorney-client relationship. But as a preface and sort of responding to Judith, Mental Health Advocacy Services started 40 years ago providing legal representation to individuals in state hospitals here in Los Angeles and Orange County. And it's a perfect tie-in because, as Judith explained, there's not a lot of autonomy that goes on in institutions. Through a fight with the legislature, or in the legislature, Mental Health Advocacy Services was allowed into the hospital in 1977, and nobody really wanted to hear from us, except for the patients who were in the hospital. They loved the fact that we were there. And in that process, we basically became a voice for the patients in the hospital. We represented them on issues about whether they could get their, people were allowed to smoke then, whether they could get their cigarettes, whether they could get a grounds pass, whether they could get out, whether they were getting too much medication. These were all individuals who had been found to be hospital or to qualify for hospital by meeting the Lerner-Wren Short Act of being dangerous to themselves or others or gravely disabled as a result of a mental disorder. And we went out there and we went into the main waiting room and we sort of said, does anybody want to talk to a lawyer or a law student? I was a law student then, not a lawyer. And we would have a bunch of people who want to talk to us. And you know what? Almost every single one of them could tell us exactly what they wanted from us. We had no problem at all knowing that when somebody talked to us that they wanted less medication, or they wanted to go home, or they wanted to find the money that was taken from them when they came into the hospital and now nobody knows where it is. Those were all things they could talk to us about. And we could talk right back to them and we could have conversations. These were people, as I said, who were in the admissions unit of the acute psychiatric hospital, and we were able as attorneys to talk to those clients. And so as a segue into talking about that relationship of attorneys talking to clients with mental health disabilities, think about the conference so far today, and there's one takeaway that I sort of think is very, very important from the whole morning, which was that supportive decision-making is not an outcome. It's not something that we strive for. It's a methodology. It's a way of approaching problems. And while we have a much more sort of refined way of looking at it and measuring it today and in this project, it's not something that we weren't doing 40 years ago when we were going out to Metropolitan State Hospital and asking a client what they wanted and then trying to get it for them. And so it's not new. And it's had a lot of different names. In other litigation I've been involved with, we call it looking for the least restrictive alternative. The fact that, you know, people are entitled to maximize their autonomy to the extent, unless the government can show there's a strong enough interest to take it away. In other litigation, it's called finding a reasonable accommodation, finding some way for people to actually do what everybody else does, despite the fact that they can't quite do it unless they're accommodated. Finding a way to get clients to work with their lawyers is a requirement of the Americans with Disabilities Act, among other things. Having said all that, you know, in the 40 years we've been providing legal services, I would say that 98% of our cases, we've had no problems communicating with our clients and actually doing what all lawyers do. And you heard Dean Guzman at the beginning say what lawyers do. Lawyers assist their clients. They represent their clients. Their client comes to them with a problem and they say, they hire them, they fix it. But they don't just do whatever the client says. They actually talk to the client. They provide information to the client. They give advice to the client, but ultimately it's the client who then tells the lawyer ultimately what they want. So one thing I will posit is, as we think about this, supportive decision making and who the supporters are, I think there is one way of thinking of an individual's attorney as part of the support in decision making. An attorney should be part of that supportive decision making process. That's our jobs. That's what we do with all of our clients who have no disabilities. We assist them in making the best decision possible. We don't make the decision for them. We assist them. So it's not at all difficult to understand from the attorney point of view that this makes sense. This is how we operate. The problem comes, and we saw it in the earlier panels, when we get to an extreme. If it's a process, you want to make sure the process there's fidelity to the process, that we really do care about structured decision making. We really do care about maximizing autonomy and choice. That doesn't mean that autonomy and choice will always win out. And so part of the difficulty going forward is assuring, that there are processes in place. One of the reasons people are so aggravated with conservatorship or guardianships is because not so much in theory they don't necessarily work, but in practice. In practice, they become blanket stamps saying this person can make no choices. And that's nobody in this room would want that. It's really, how do you make sure the system works, and only those people where ultimately no other way of making a decision for them is possible are the ones who ultimately lose that right to make that kind of choice. In the attorney-client context, it comes down to what can a lawyer do when their client actually is at a point where they have diminished capacity or are unable to assist in the litigation process. In criminal law, lawyers' responsibility is let the court know, and the court, if they agree, will stop the case, send that person away until they can be restored to competency. The case won't go forward. That's not true on the civil side. Civil side, you have to figure out some solutions to how do you deal with a client who can't really, has some diminished capacity in working with you as a lawyer and making the final decisions that they ultimately have to make. And in doing that, besides the difficulty of evaluating that, there's a key fundamental principle, which is people are competent until proven otherwise. In other words, there's a presumption of competency. You have to assume that they're able to tell you what they want, and it's only, with significant evidence that one would, discount what your client is telling you and say that might not be the case. I remember a case that we did in our office. It was in an immigration proceeding where we were representing a individual who had a very serious mental disorder and, was unable to really sort of clearly indicate what it was that they really wanted and sort of the reasons for it. And they were in a position where we were trying to keep them in this country, and they were very happy about that on one day, and then the next day they said, no, I don't want to be here anymore. I want to get out. I want to go back to where I came from. And it clearly, again, they clearly were not totally in touch with the reality of their situation, but they one day were able to tell us yes, one day we were able to tell us no, and we were in a very difficult spot. And that's the hard case for us. It's the case where our client is unable to give us the instruction we really need. But even then, we talked about, should we get a guardian ad litem? A guardian ad litem, by the way, is sort of guardianship light, guardianship for one specific purpose, which is to help in the particular litigation or the particular legal issue that's involved. And judges can appoint guardian ad litems in a very different kind of process than in a general guardianship kind of probate situation. And so a guardian ad litem is a tool that can be used if somebody really can't decide for themselves. And then a guardian ad litem could be appointed to make that decision. But even then, you would wonder that shouldn't this whole theory of supportive decision-making carry through? And the guardian ad litem's job, which generally is to decide what's the best interest of the client, shouldn't that really be tempered by first determining what is the client's wishes, what the client would choose for themselves, and only in that little area that the client can't express their interest be able to make a final decision. And again, that's the sort of modified way of thinking about how one would make this actually work. So in our case, it was sort of, we didn't, that seemed like a drastic measure for us. So what we decided is, the person, and lawyers, we certainly had the luxury of making certain choices that made our choices easier because, the longer we stalled, the longer the person stayed in this country, and we were able to see how it all turned out from the client's point of view. But that's what we did. We stalled. We went back and visited the client at different times of the day. We went back and visited the client on different days of the week, and to see if we could get a more consistent answer. And ultimately, I think we were able to figure out a consistent answer. Now, there's other models of supportive decision-making that didn't apply here because they involved bringing in other people who could help, but this was somebody who had no other people around him. So it was really the lawyer and the client, and we were going to figure out how to get through that process. So those create the dilemmas, and there's also, I think, I've noticed, in the years of sort of dealing on the policy level with this, there's some tension between the disability bar, those people who represent people with disabilities, and the elder bar, the folks who represent elders who often are subject to abuse and particularly fiduciary abuse and other things. And the elder bar seems to think about this as, you know, if we don't jump in and do something protective, the person's going to be harmed in a very, very serious way. And their world is sort of that of protection. And the disability bars is one of empowerment, of you know, trying to protect rights as opposed to protect property and life. And that conflict, I think, comes out in the sort of very diverse ethical rules that are have been promulgated to assist lawyers, because each state has its own set of ethics. The federal government has that. The ABA has a model set of a model rule, and they're very, very different. And I thought I would end by just sort of sharing with you sort of how this ethical issue gets played out in what we do in California today, what the ABA recommends, and just this month, an ethical rule has been approved by the California Bar Association that's in front of the California Supreme Court for potential acknowledgement, or whatever the Supreme Court does in this case, but it would become final if the Supreme Court approves it. But I want to start with where California is first. And California, before this change in ethics, has no provision for assisting a client with diminished capacity from the attorney's point of view. The attorney really is sort of left to work it through themselves. There's 3 different ethics opinions from the state bar over time that have identified 3 reasons why attorneys can't just turn and say, I need a guardianship or a conservatorship, or I need some kind of protective help for my client. And they first are the ethical rule requiring confidentiality, that the state bar says that it would be a breach of a client's confidence to share that information with anybody else without the client's consent. Second, the fact that the lawyer is prohibited from taking an adverse position to their client, and seeking a conservatorship, guardianship would be seen as an adverse interest to the client's liberty interest. And so the state bar has said you can't do that either. And then finally, to the extent that conflicts of interest can be waived by a client, then the very claim that the client has diminished capacity calls into question whether the kind of informed consent they could give to the waiver would allow you to deal with the conflict of interest. So in California, your only option, if you can't do what your client wants, really is to ask to be relieved from the case, because you can't actually take other steps. That, at the other extreme, was addressed probably 20 years ago by the American Bar Association in their model rules. And I do want to read that model rule very quickly to you. I think I have enough time. Yeah, a couple minutes. And then talk to you about how California has modified that to sort of find a place that I think supported decision-making can actually fit. But the federal ABA model rule is, or the ABA model rule, when a client's capacity to make adequately considered decisions in connection with a representation is diminished, whether because of minority, mental impairment, or some other reason, the lawyer shall, as far as reasonably possible, maintain a normal client-lawyer relationship with the client. That normal meaning you do what the client tells you to do. When the lawyer reasonably believes that the client has diminished capacity, is at risk of substantial physical, financial, or other harm unless action is taken, and cannot adequately act in the client's own interest, and the lawyer may take reasonably necessary protective actions, including consulting with individuals or entities that have the ability to take action to protect the client, and in appropriate cases seeking the appointment of a guardian ad litem, conservator, or guardian. So the ABA actually takes a position, if you can't handle this as a lawyer communicating with your client, go ahead, breach confidentiality, and then in another section they say breach, or in the notes they say that implied is that that kind of a breach of confidentiality would not be a violation of your oath of confidence. And And so that has never been the case in California, and certainly the disability community has fought against that for a long time. What was just approved by the State Board of Governors and sent to the Supreme Court for final approval was a new Rule 114, which we've never had in California before, for clients with diminished capacity, with some major differences from the ABA rule, and they tie very much into the underlying concepts of what we're talking about today, because yes, you can seek protective action if your client is in danger and can't significantly make decisions and can't adequately look under their own interests, but only with the client's consent. Consent is absolutely required before you can breach their confidentiality under the new rule that's being proposed. So it allows for an out, but it still makes the lawyer act as that entity that's supposed to support the decision of their client. They have to work with their client. If the client doesn't understand what it is you're asking, you have to actually spend time and figure out how to get your client to understand if you really think you need to get their consent in order to do this. And so if in obtaining consent before taking protective action as authorized by paragraph B, a lawyer must take all steps reasonably necessary to preserve client confidentiality and decision-making authority, which include explaining to the client the need to take protective action and obtaining the client's consent to take that protective action. And so it forces the lawyer, in fact, into that role. The one other way to get consent, by the way, is through basically an advance directive. That the D section says obtaining advanced information by written consent to a protective action. The danger there, of course, is that it's going to be another form a lawyer makes you sign before the lawyer will take your case, and there won't be anybody really explaining to you why it is necessary or what your options are and why you may or may not want to sign that piece of paper.
Anyway, so it sounds like that's a good model for informed consent for supported decision making.
Yeah,
partly,
no,
right? I mean,
I'm suggesting
something that should be even built into the consent when these relationships are started, right?
Right.
I mean, is that what you're suggesting in terms of
right?
Yeah,
and just to find, I know that was stop talking.
I'm trying. Yes,
but to finalize what
Yeah.
that point is, I mean, what's necessary going forward, assuming this is approved, and it will be, is actually how do you formalize supportive decision-making into this kind of a process, into a guardian ad litem process, into a attorney-client process.
Well, and a blunt, careful explanation to the person who is, who is at the center of this, what the hell is going on, right? I mean, that's a lot of legal language for the lawyers and so on, but it's actually the person who needs to understand, okay, so it's my decision, and if you're going to break confidentiality, that's also my decision.
That is correct.
Yeah, okay. All right. Thank you, Jim. We're going to move on here. We're lucky to have Judge Ginger Lerner-Wren with us today. If you don't know who she is, I'm going to tell you right now. She's a pioneer in mental health, of the first mental health court in the United States in 1997, Broward County, Florida. Broward's court, by the way, was the congressional model for America's Law Enforcement and Mental Health Project Act of 2000. Judge Lerner-Wren was appointed by George W. Bush as a member of the President's New Freedom Commission on Mental Health. Many of you remember that. She's an adjunct professor for Nova Southeastern University and a contributor to the Huffington Post also on therapeutic justice and disability rights. So, Judge Lerner-Wren, good to have you. Go ahead, I'm right here.
Where is that reporter? First of all, I cannot tell you what a thrill this is. Now, Ellen, Professor Sachs, you know, you are a legend, and I am just, when I got this invitation, if you would have seen me in court, you would not have believed it. And so I'm just so thrilled to be here. You can see I even dressed like the decor. I don't even know how that happened, but I did it, and it worked, I think. I love it. This is such a beautiful, inspiring room, and I just enjoyed every single piece of this program. And, you know, kudos to Jonathan. I just want to say, because this subject matter, look, it's old, it's new, it's evolving, because everything is evolving in terms of mental health and behavioral health and what we're doing in problem-solving courts. I mean, it's dizzying that the acceleration and the evolution of criminal justice and juvenile justice and where we've come in humanizing justice, I mean, all of this. There's no rights, there's no wrongs. We're really exploring how can we activate humanism and human rights through the law, where there's vexing social and political and economic problems. Am I right, Professor? I mean, did I nail that? Do I get an A? I've been thinking all day about how to braid all these different dialogues together for us, so we leave here cogent, so we leave here feeling that we are really talking, we might be talking about what's happening in Hungary and what's happening in elder law and what's happening in juvenile law, right? And what everybody's been through and where is that, and these advocates and suicide prevention, and it's dizzying, isn't it really, in terms of problem solving? And yet, the truth, the fundamental truth is that it doesn't really take much in order to create change. It does take outrage. It does take passion, correct? It does take thought leaders. And gosh darn it, it takes the press.
Thank you. Yeah.
And, so I really just think that together, all of us, whether it's in the legal sphere and all the other interdisciplinary spheres, that we've got when we come together, to solve problems, just like we did in Broward County. And, come June 23rd, we're going to have a beautiful celebration in Broward County, because without any money, without any grants, without any permission, without anything other than sheer outrage, desperation, correct? And I'm telling you, maybe enough people sitting at 3 of these tables. That's it. 3 tables in this room came together for years. And they met as a work group to seek solutions for what they perceived was an overrepresentation of people pouring into the Broward County Jail and an unlikely savior, that's what PBS Frontline called Aaron Wynn, a 19-year-old boy getting ready for college on his motorcycle. He loved the ocean, he loves sports, he has the sweetest parents, and he got hit by a car. And he suffered such traumatic injuries that, in addition to the traumatic brain injury, we were talking earlier about, all of these conflicting and moving diagnoses, that the Wynn family could not get help for Aaron. Aaron's brain injury ended up being really the most disabling part of that motorcycle accident, where he just, because of the frontal lobe damage, he couldn't regulate his behavior. And so he gets in this is just the beginning of the Odyssey, he gets in an altercation with a police officer, goes before a court, the judge finds him mentally, legally incompetent to proceed. He gets sent to a Florida State forensic hospital, where, according to expert medical review, when the family sued the state of Florida for civil rights violation, Aaron spent 2.5 years, 2.5 years in 4- and 5-point restraint in solitary confinement. Straight. When he was released, Ellen, his family had tried everything up to that point. No everyday call. These were not poor people. These were high-end, right, middle-class folks living in a sprawling ranch home in Broward County. There was nobody to help them. They couldn't get any treatment, no services, no rehabilitation, nothing. When Aaron was released without notice, no discharge plan, forget about reentry planning, nothing, the Wynn family found themselves trapped in exactly the same nightmare. Within a few months, Aaron is in, like, I guess it would be, you have like here, you have like Ralph's grocery store. Is that like one of your major chains? Is that right? In Florida, we have Publix. That's ours. No mountains, but we have Publix. And so Aaron, the story is that Aaron, it's important. The story is Aaron's going to check out. He goes and he buys some lunch meat or something. He's at the cashier. Now he comes out of the forensic hospital diagnosed not only with a traumatic brain injury, now he's got PTSD and schizophrenia, and he's at the cashier. Something happens, and he has a panic attack, and he darts out of the grocery store, and he tragically collides with an 85-year-old woman by the name of Pauline Johnson, who crashes to the sidewalk. She dies ultimately the next day of head injuries, and Aaron is now charged with murder. Welcome to Florida. 49th funded in the United States, the third largest state in the United States. And we were talking earlier that our mental health per capita is 6 grand lattes from Starbucks. I'm not kidding. It's $38.99. We've got almost 1 million people that have no health insurance, and by the wisdom of our legislature, we have no Medicaid expansion. Now, forget about a millionaire's tax. I mean, we are far away from what's happening in this gorgeous state. And Howard Finkelstein is the public defender for Broward County. You have to look him up. Back then, he was the chief public defender. He is a hippie throwback. He's got a long braid that he wears, a singular back braid, correct? And he is one of the most vicious, charismatic defense lawyers in Broward County. He's also a celebrity. He has his own news show called Help Me Howard, because he was such a great news analyst during the O.J. Simpson trial. And Howard cannot walk down the street without being recognized. Now, Howard gets assigned to represent Aaron Wynn. And Howard thinks, and he's told this story in Broward County 1 million times, he's going to go talk to the Wynn family, and he's going to tell the Wynn family what he's planning on doing for their son. He walks into the living room, and just to make a long story short, Jane Wynn, who's British, by the way, Jewish family, but British, sits him down and basically very graciously says, I think we need to tell you something. And then goes on to tell Howard the story of their family's nightmare and hell, and what happened to their son, and how they could not get anybody in Broward County to listen to them, to get them help. Howard will tell you that he had an awakening that exponentially woke up 3 tables in a room. Because his awakening led to a task force that, after meeting a diverse task force, mental health providers, criminal justice stakeholders, 2 systems of care that have always been, 2 systems rather, that have always been completely independent from one another, have now come together in order to try to solve a vexing problem. What are we going to do? Howard had written the Broward County grand jury. They took the case. They issued a scathing report about Broward County's mental health system and the state of mental health in Broward County, finding it deplorable, leaderless, and accountable to no one. No continuum of care, 0. Couldn't get anybody on the phone. No, we were talking about accountability at the during lunch. No accountability, 0. And so after this task force met and met and met, in a moment of frustration, the chair of the task force asked Howard, "Howard, just tell us already, what do you want?" Howard says, and I don't even know why, "I want my own bleeping court." Now, there was at the time a drug court in Miami-Dade. Ironically, I mean, we talked about desperation leading to innovation. How South Florida is such a hotbed of innovation, I will never know, other than Janet Reno. Thank God for Janet. Bless her. Rest in peace.
Yes.
Amazing. So we talked about prosecutors. Who did we talk about the prosecutors with? I can't remember, but earlier today, she was prosecutor, loved policy. Her father was from the Netherlands during World War II. Yep, human rights, social justice permeated that family. And sure enough, they had the drug court. Howard just wanted a court of refuge. He wanted a court of refuge. We didn't know if anything was going to work. Who knew? Dignity, restoration of personhood, choice, right? That's all we cared about. What can we do for you? We are here for you. Tell us. We'll stand on our head for you. We're getting you out of jail. What do you need? Right? We were on a rescue mission, and we're still on a rescue mission, and we've rescued over 20,000 people out of our local jail with no money.
Wow.
Hello? Now, will is free. Did you get that? Political will is free. Do what you want. You don't know what to do? It doesn't matter. Do it anyway. You want to fix something? Put on a therapeutic lens. Look up therapeutic jurisprudence. And do it. What have you got to lose? Your state is rich. No excuses. No excuses. David knows that. Watched the President's Commission, and we fought to get trauma into the President's Commission report. Nobody knows that. The women on the commission fought, Ellen, just to get trauma into the report. Nobody knows that. I'm telling you that. We got recovery right because of Dan Fisher and a few others, Charles Carey, right?
All right. I think we got the message. Get your
Okay.
ass off your ass and do something. Is that what we're talking about? All right.
All good decision
Are you
making
finger
is
wagging
good,
California right there? All right.
As long as it's shared.
Okay. What a panel. What a day. This was fantastic. We're not done. We can take some questions, but we're pretty close to done. So if you guys have got anything you want to ask, and this is the marathon group that hung in for the whole day. So anybody have questions for the panelists here? We'll have a couple, time for a couple, or not. Yes.
Just to end on maybe like a really inspiring.
Oh, I'm sorry, I haven't been inspired.
No, keep the inspiration going. Especially for us lay people out here. How do you think law can positively help supported decision making?
Well, I think it's the applications. You know, it's the applications. So, for example, if I'm sorry, maybe we can come back sometime, Ellen, seriously, and talk about actually what happens in court. But, you know, in court, it's open dialogue. You know, we talk about open dialogues from the Netherlands, and if you take the open dialogue process and you plunk it into a courtroom, and we have a clinician in the courtroom, that's the dialoguing. And if people are telling stories and you're getting validated and we're giving voice, correct, to the consumer, to the court consumer, and I'm looking at them and I'm listening actively with empathy, and I'm like, you know, how do you feel, Ellen? Like you're listened to, right? Like we care about you? And if I'm gonna use a court process to hold systems accountable to the people that I'm seeing, that's how that happens. So if you're applying a healing justice in a non-adversarial court with a therapeutic approach, that's how that happens.
Anyone else want to add? Jim or Judith?
Well, I mean, it's an incredibly unusual approach, and it's something that I think would be, I want to go see it and figure out how to replicate it. I mean, it's remarkable. It's putting human dignity at the very front of the you know, the whole process and the system, and there's nothing more important than that.
I would add that just the work of the study that the Blatt Institute and the Sachs Institute are doing in collecting data. I mean, I think ultimately, you heard Mayor Steinberg say that he needed data about schools and mental health to go to the legislature. The more data we have about how people do better when given more autonomy, the easier it is to change public policy.
Mm-hmm. Yeah, that's a good way to end, I think. They do have money now, and they've got a big study going between Burton Blatt and the Sachs Institute. And we're going to see. We're going to see if it's a good idea. It sure sounds good, but as I say, it's good to test just to make sure it's not a bad idea. I think it's probably good. All right. Hey, thank you so much, Ellen Sachs and everybody. Nice to be able to host this.
That was great. You know, I loved the...
Hi, everybody. Just wanted to thank everybody for coming. I really appreciate it. The panelists have been phenomenal. Thank you, panelists, and thank you for all the staff, for all the help you've done, all the work you've done. And one final thanks again to Will. So let's go out to the reception, which is sponsored and hosted by the Sidley Austin Law Firm. Thank you.